2nd August 2026 is everywhere right now, most of it wrong. It is not when AI systems become high risk. That moved to December 2027. But three things genuinely do change on this date, and if you're only tracking the headline, you'll miss all three. We'll cover the three things that genuinely take effect on this date. Article 50's transparency duties, the enforcement powers and penalties behind them, and the Commission's power to fine over general purpose AI. Quick orientation, because the EUAI Act has more than one clock running. High-risk obligations for recruitment, credit scoring, and insurance. That's the 2nd of December, 2027, under the Digital Omnibus, adopted by the Council on the 29th of June this year. 2nd of August 2026 is a different date for different duties. Article 50 is the single most broadly applicable duty in the whole Act. It doesn't care whether your use case is high risk. From 2nd August, four things apply. Tell people when they're talking to AI, unless it's obvious. Mark AI generated audio, image, video, and text, so it's machine-readable and detectable. Tell people when they're exposed to emotion recognition or biometric categorization. And label deep fakes and synthetic content as artificially generated. Article 50 is an EUAI Act duty specifically. But if you operate across borders, similar disclosure rules are showing up elsewhere too. We keep a free one-page cheat sheet per jurisdiction, the regulator, the key laws, and a quarterly action checklist. There is one grace period, and it's narrower than people assume. The machine-readable marking duty, Article 50, Paragraph 2, gets a 4-month grace period to 2nd December 2026. But only for general-purpose AI systems already on the market before 2nd August 2026. Anything placed on the market on or after that date gets no grace at all. From this date, national market surveillance authorities can actually investigate and sanction. The ceiling, 15 million euros, or 3% of worldwide annual turnover, whichever is higher. That's not a high-risk-only number. It covers Article 50 breaches too. General-purpose AI obligations aren't new. They've applied since 2nd August 2025, a full year already. What changes on 2nd August 2026 is narrower but consequential. The Commission's power to actually fine a GPAI provider for breaching them switches on. If terms like GPAI, machine-readable marking, or deepfake labeling are new to you, that's normal. This is dense language. We publish a free glossary, 80 terms across the EUAI Act, NIST AIRMF, ISO 42001, and GDPR. Practically, four things worth checking now. Do your customer-facing tools disclose when someone's talking to AI, where that isn't obvious? Is generative output, audio, image, video, text, machine-marked? Are deepfakes and synthetic media you publish labeled as such? And if you provide or deploy a general-purpose AI model, is your compliance file ready for an authority that can now actually fine you? Dates like 2nd August don't stay still. The Digital Omnibus itself proves that. We send a free weekly brief Friday mornings summarizing what actually changed that week with citations, so you're not relying on a video that could be stale in 6 months. If you're not sure which of these actually apply to your organization, there's a free way to check. No account, about 90 seconds. And if any of this points to something you actually need documented, a policy update, an incident process, a vendor check. Every sample output is free to read before you decide anything. Three things change on 2nd August. Article 50's transparency duties, real enforcement power and penalties, and the Commission's power to fine over general-purpose AI. There's a free AI readiness score linked below, plus a free weekly brief that tracks dates like this one so you don't have to. Subscribe for AI regulation explained in plain English, no hype. Watch next. The full state of AI regulation in 2026, all 378 laws mapped.